Good afternoon, everyone. This is Ron Pridgeon. I hope you can hear me.
I can.
Hi, Ron. Kenny here. I can hear you.
I can hear.
Very good. Thank you. We will try to get started at or as soon as close to 3 as we can. See, everybody's kind of jumping on WebEx at the same time. And I think I see Madam Court Reporter Bev Bench. Thank you. So hopefully we'll get started, like I said, at 3 or just a few minutes thereafter.
Hello, I just want to check my mic. You guys hear me?
Yes.
Working.
I can hear you. Can you hear me?
Yes.
Thank you.
And let me see what commissioners are online. I believe Commissioner Kenny, you already responded. Mr. Chairman, I think I see that you're just now joining. Welcome. So I think I have Chairman Sylvie and Commissioner Kenny on the line. I think Commissioner Roop will be joining us later. I'm not sure about Commissioners Coleman or Holzman yet.
Thank you. Good afternoon, Judge.
Thank you, Mr. Chairman. And because we're doing this via WebEx, I can't just look out into the hearing room and make sure everybody's here before we get started. I do see people here from Spire. I think Mr. Opitz is logged on for Renew Missouri.
Holzman.
Commissioner Holzman, good afternoon, sir.
Thank you.
Anyone here on behalf of the National Housing Trust? MIEC, I believe Ms. Plesha, are you here?
Yes, I'm here. Thank you. And our witness, Greg Meyer, is here as well.
Very good. Thank you. And I think I saw Mr. Woodsmall, folks here from staff and public counsel. So I think all the parties are present except for perhaps National Housing Trust. Anybody here, Mr. Owen, Mr. Linares, anybody here for National Housing Trust? Let me give them just a few more minutes. And Madam Court Reporter, will you be ready when I'm ready to go here in a minute?
Yes, I'm ready whenever you are.
Very good. Thank you.
I will keep myself muted, and if you see me like this, that means I'm having a problem.
Okay, I will try to keep an eye out. I've got a bunch of folks, and it depends on which screen I use, but I'll do my best to keep you on my screen. Thank you.
Okay.
Let me just give National Housing Trust another few more minutes, and then we will begin. Mr. Linares, good afternoon. You're here for National Housing Trust, is that correct?
Yes, Judge. Finally got my sound to work. Thank you very much.
Very good. Thank you. I think everyone is here. Anything from anyone before we go on the record? All right, hearing nothing. Madam Court Reporter, are you ready?
Yes, Judge.
All right, thank you. All right, good afternoon. We are on the record. This is the on the record presentation of file number GU-2020-0376. That's in regards to Spire's requested accounting authority order case. I am Ron Pridgeon. I'm the regulatory law judge assigned to preside over this on the record presentation. It is being held on October 19th, 2020 at 3 o'clock in the afternoon. We are doing this via WebEx due to the COVID-19 pandemic. I would like to get verbal entries of appearance from counsel, please. Let me begin with the company.
Good afternoon. Goldie Boxtruck and Matt Applington are at 700 Market Street, St. Louis, Missouri, 63101.
Ms. Boxtruck, thank you. On behalf of the staff of the commission, please.
Good afternoon, Judge. On behalf of the staff, Jamie Myers, 200 Madison Street, P.O. Box 360, Jefferson City, Missouri, 65102. My telephone number is 573-526-6036.
Ms. Myers, thank you. On behalf of the Office of the Public Counsel, please.
Good afternoon, Judge. Caleb Hall appearing on behalf of the Office of Public Counsel. Our office is 200 Madison Street, P.O. Box 2230, Jefferson City, Missouri, 65102.
Mr. Hall, thank you. On behalf of MECG, please.
Thank you, Your Honor. David Woodsmall on behalf of MECG.
Mr. Woodsmall, thank you. On behalf of MIEC, please.
Diana Plusha of the law firm Curtis Hines, Garrett and O'Keefe, 130 South Beamiston, St. Louis, Missouri, 63105.
Ms. Plusha, thank you. On behalf of the National Housing Trust, please.
Thank you, Judge. This is Andrew Linares for the National Housing Trust. My address is 3115 South Grand Avenue, Suite 600, St. Louis, Missouri, 63118.
Mr. Linares, thank you. On behalf of Renew Missouri, please.
Thank you, Judge. Tim Opitz on behalf of Renew Missouri Advocates.
Mr. Opitz, thank you. I don't think I've overlooked anyone, but just in case, did I miss someone who needed to enter an appearance? All right. Hearing nothing, what I'd like to do is, in lieu of actually calling people to a podium, simply just ask parties one at a time to give some sort of brief overview of your position on the stipulation, and then be prepared to answer bench questions. My plan is to start with the company, then go to staff, public counsel, and then the interveners. Anything further from either the parties or the bench before Spire makes a presentation to the commission? Okay, hearing nothing, just a reminder, if you aren't speaking or don't plan to speak, if you could mute your device so we don't get so much crosstalk or noise. So if there's nothing further from council or the parties. All right, Ms. Boxtruck, when you're ready, ma'am.
Thank you, Judge. May it please the Commission. We are meeting here today due to an extraordinary event, the COVID-19 pandemic, an event that shook the nation and the state of Missouri as early as March of this year, the impacts of which still affect us to this day, as is evident by the fact that we are not able, as we traditionally are, to conduct this presentation in person. The event is so extraordinary, it is unsure when we will recover from its wake. We appreciate the Commission's regard for the safety of all parties involved to allow for this remote hearing. All parties to this case have worked hard to reach a unanimous agreement that will, 1, aid in the sustainability of Spire so that we may continue to provide the essential utility service that Missourians need, and 2, inure benefits to Spire's customers impacted by COVID-19 during these difficult times. The agreement reached allows Spire to defer into a regulatory asset for potential recovery in the company's next general rate proceeding those incremental costs related to the COVID-19 pandemic beginning March 1 of this year and ending March 31, 2021, with the option to extend this time period upon agreement of the parties and commission order. These costs include new operating and maintenance expenses related to protecting employees and customers, which include items such as additional cleaning of facilities or vehicles and PPE. Increased bad debt expense, costs related to any new assistance programs implemented to aid natural gas customers with their bills during the pandemic, increased field employee overtime, lost revenues up to the amount included in rates related to waived late payment fees, reconnection charges, and disconnection charges. The company agrees not to defer any other type of lost revenues not specified under the agreement, which means the company will not defer lost revenues related to a reduction in load. The company also agrees to defer savings from operating cost reductions that the company is experiencing directly related to COVID-19, such as reduced travel and office expenses as an offset to increased expenses. There is also a provision in the agreement pertaining to quarterly reporting requirements that would track cost increases and decreases, as well as a series of customer information regarding disconnections, reconnections, and arrearages. The agreement also includes a customer arrearage payment program. Spire has agreed to create an arrearage program for those customers who have either lost their jobs, been furloughed, or lost income since March 1 of this year due to COVID-19. Participating customers may receive up to $400 towards their natural gas bill under this program. Also, for the benefit of its customers, Spire will make available an extended payment program option of 18 months and not report information to third-party credit agencies. We appreciate the Commission having an on-the-record presentation on this unanimous agreement to keep the stipulation procedurally moving. Spire is unique among Missouri utilities in that it is a gas-only utility, and we are heading into the critical winter heating season. That's why it is important to obtain clarity on this stipulation so that we can timely offer these customer programs to those impacted by COVID-19. Spire has Scott Weitzel, Managing Director of Regulatory and Legislative Affairs, available to answer any questions the Commission may have. Thank you.
Ms. Boxstruck, thank you. Let me see if we have any questions from the bench. Mr. Chairman.
Judge, trying to find my mute button there. Yes, I do have a few questions. Thank you. And while I'm directing these questions now, obviously to Spire, I would say if any of the other parties disagree or have a different take on the answers given, please share those at the appropriate time. When does the company anticipate filing its next general rate case?
As you may have, sorry. Go ahead, Scott. Are you planning on answering that? We recently filed our 60-day notice, so we do anticipate that happening probably before the end of this year.
Okay. And you guys began sending out disconnection notice in July, is that right?
Yes, that's correct.
Okay, and how long does it take before non-payments are put onto the books and considered bad debt?
I will let Mr. Weitzel answer that.
Hello, Chairman.
Good morning. Good afternoon.
Are you on, Golden?
I'm on.
If
We'll try this again. Hello, Chairman. Thank you. The question was, how long does it take for bad debt to hit the books of Spire? Was that your question, sir? We have a ratio and a formula, and we could follow up with our actual accountants and controllers, but we have a ratio and a formula where we forecast that out and make those adjustments, but it takes several months for an actual bad debt write down.
okay.
We won't actually know until we go through the full collections process, potentially a third party. So, it could take 8 months till we know the actual write-off or bad debt amount.
Okay, thank you. In paragraph 7, it talks about savings to be deferred, and I believe it's sub H says any direct federal or state assistance Spire or Spire Inc. receives related to COVID-19 relief. Can someone describe to me what type of federal or state assistance this is referring to, and have you received any?
I could take a stab at it. With all the stimulus going on at the federal level, items being looked at the state, if Spire received any COVID assistance, any COVID relief as a corporation or an entity, we then would deduct that from our expenses. But as of right now, the company has not received or does not plan to seek any type of assistance from the state or federal government specifically relating to COVID-19.
Okay, thank you. In paragraph 8, it talks about the duration of the AAO, and it says the duration of this time period may be extended or renewed upon agreement of the parties and subsequent order of the commission approving the agreement or by a separate order of the commission. So does that mean that if the parties don't reach an agreement on extending the period of the AAO past March 31st of 2021, that the commission can make a determination to extend the length of this agreement without modification? And what is the difference in this language between extended and renewed?
I might have the lawyers help me out on that, but I think generally, if with the unpredictable and unknown of COVID, if we go into more lockdowns, more issues, more circumstances or situations impacting our customers or the company, the parties could reconvene, have those discussions, and then maybe come to the commission and ask for an extension depending on the circumstances. So with the unknowns out there, we wanted to give us some options if things got worse.
Okay. In paragraph 9, we talked about some reporting requirements. I just want to confirm that the report of the information listed in paragraph 9 will be filed in this case docket or another docket and available to commissioners and not just provided to the other parties. Is that right?
Yes.
Okay. And is that the same, I guess, with all of the reports? I think it's paragraph 11 might have another reporting requirement in it, but is it safe to assume that whatever reports are required in this stipulation are going to be available to the commissioners and not just the parties?
Correct.
Okay. And then paragraph 15, we talk about the Evergy appeal in WD 83319. It says that the signatories agree that if the court renders a decision pertaining to WD 83319 or subsequent appeal that renders accounting authority orders invalid, this agreement becomes null and void, and the company agrees to adjust its books or records consistent with the court's decisions. So a couple questions there. What is meant exactly by renders accounting authority orders invalid? Are we imagining a decision where the court says no accounting authority order is authorized ever? Is that what that means?
Scott Weitzel, if you don't mind, I'll interject in.
Sure, absolutely.
Commissioner Sylvie, this is Caleb Hall from Missouri's Office of Public Counsel. This term was requested from OPC and MECG. Our interpretation of what Evergy's position was at the Court of Appeals regarding their latest appeal of an accounting authority order, this commission ordered for Evergy to account for costs related to the closure of a power plant, was that the company was arguing to the court that the accounting authority order in question was a collateral attack. We further saw that their argument was that any accounting authority order, such that any accounting order that happens after rate case, is a collateral attack upon that rate case. If Evergy's argument wins at the Missouri Court of Appeals, our legal opinion is that then the integrity of all accounting authority orders is undermined. The Western District Court of Appeals did not agree with Evergy's argument, and the appeal before the Supreme Court is still pending. That is why we asked for this term to be included.
Okay, so it is imagining a decision where accounting authority orders would essentially just disappear from Missouri regulatory law, not specific to that case.
We are imagining some type of, for lack of a better term, doomsday scenario. Yes, I understand that Evergy, Missouri may disagree with our legal opinion. They are on this call as well. They should speak up if they wish to explain their countervailing opinion. I will posit to you, Chairman, that the appeals to the Supreme Court it's a remedy of last resort. It is not often granted. So this term is likely not going to implicate any future proceeding, but is a term that we asked for nonetheless out of an exercise of due caution.
Okay, and just so I'm clear though, let's say that appeal results in the court deciding that particular AAO was unfounded. That does not trigger this clause. We're talking about a finding by the court that any AAO is a collateral attack on the previous rate case.
Any type of conclusion on a prospective case is going to have to depend on the actual wording of the case. And I don't mean to be flippant, Chairman. It's simply a matter of if a subsequent court opinion is written such that the nature of the accounting authority order is treated as a collateral attack, I believe that then that undermines the integrity of all future AAOs. Of course, that all depends on the wording of any court opinion.
Commissioner, this is Matt Applington for the company. I just would draw your attention to the fact that in paragraph 15, it refers to an appellate decision that renders accounting authority orders, plural, invalid. And the idea behind that is that, yes, if the court were somehow to say that no more AAOs for anybody, then this AAO would obviously be invalid and we would have to undo all of this. But no, I mean, to your point, I don't think that's likely. So.
Okay, that's what I was wanting to make sure I understand clearly. It wasn't just that particular AAO. If Evergy wins this unrelated case, that this goes away. It would be if that ruling says all AAOs or is broadly applied to all AAOs, that it would apply to this.
Correct. If there's a fundamental shift in Missouri law, then everyone will have to reset, but that seems unlikely.
Okay, thank you. And then in paragraph 17, there's a description of eligible customers receiving a credit upon joining a payment plan. Is that only available to residential customers?
That is a good question, Chairman. Customers in our definition could be any class. I think in the spirit of this stipulation, it was predominantly developed for residential, but that's something that hasn't been defined in this.
Okay.
As it stands right now, customers could be any customer of Spire.
Okay. All right. Thank you. Those are all the questions I have now at this time, Judge. Thank you.
Thank you. Commissioner Kenny, any questions, sir?
No, I have no questions. I'm just listening. Thank you. I appreciate it.
All right, very good. Thank you. Commissioner Roop, have you joined us?
I have joined, but I do not have questions at this time. Thank you.
Very good. Thank you, sir. Commissioner Coleman, any questions?
No questions from me. Thank you.
Thank you. Commissioner Holzman, any questions?
Yes, I have a few. In paragraph 17 of the stipulation contains a provision with regard to COVID-19 customer average payment plan, stating that participating customers would only be allowed to miss monthly payments during the arrearage period or run the risk of being removed from the payment plan. I have a couple questions surrounding that statement there. Number one, what is meant by missed monthly payment?
So if a customer does not make their bill paid in full, that is considered in our systems right now a missed payment.
So, given the nature of the pandemic, it's possible a customer could make a full payment under the repayment plan for several months and then be unable to make a full payment the next, if a customer is only able to make a partial payment, would that partial payment constitute a missed payment?
Yes, a partial payment is considered a non-payment in our system today, coding wise. So
Okay.
Go ahead, sir. Sorry.
Well, I was just going to follow up and say, if a customer is removed from the program for missing a monthly payment, is the customer prohibited from returning or re-enrolling in the COVID-19 customer arrearage payment plan?
I think if that customer potentially could have had further loss of income or another triggering event, that customer could come back and be a part of this program.
If they're removed from the program, are they permitted to enter into any other repayment arrangements?
No.
Okay. My next question, staying in the same paragraph, it states that the arrearage program period runs through March 21st, 2021, but then 2 sentences later, it says this payment plan will end March 31st, 2021. Can you explain the difference between these two cutoff dates?
I really can't, Commissioner. Internally, we're acting like this goes through March 31st as we're trying to develop and set up this customer program.
Okay.
Yeah, I just think, I don't think it was aligned or updated correctly, unless another party has a comment on that.
Okay. Given that Missouri is just now entering the heating season, would it seem that customer arrearages would increase, and does Spire or other parties expect customers will need additional time to pay off their arrearages?
I could give a little, some comment on that. So our customer, we're seeing about the same amount of people who've always struggled in arrears, except those customers are now moving down, carrying higher arrearage amount. So the majority of our arrears were in the $0 to $100 range, but now they're moving in the $200, $300, $400, $500, $600 range. And that's one of the reasons why we're proposing this program. So we're open, and I think that's why we also put in the 18-month repayment plan to give customers more protection, more options to deal with their past due amounts.
So that was my next question. On paragraph 18, you talk about the 18-month payment plan. Does this payment plan offer any bill credits or forgiveness?
This is a separate payment plan from the arrearage match. So it's just another option to spread that past due amount out.
So will customers have to choose between the two payment options, or will the customers be able to utilize both if they need it?
I do not know how we're programming that right now, but I would imagine it's one or the other.
Okay. My final question is, the stipulation details a process for parties to meet and discuss whether any modifications to the arrearage payment plan are needed. Would any of the above or any of the concerns I've addressed so far in this process, can you describe any triggering events that might prompt the program revision?
I could take a stab at it. That there's words and clauses in here about monthly reporting that each month we're going to all circle up and the company will report out on the success of the arrearage matching program. And I think that'll give the parties and the company an opportunity to see what's working, what might need to be changed to have a better success of getting those customers impacted by COVID on one of these programs.
Okay, thank you, Judge. That's all my questions.
All right, very good. Thank you.
Judge,
yes, go ahead.
this is Commissioner Coleman. I do have a question.
Yes, ma'am, when you're ready.
On one of the answers just given in response to Commissioner Holzman, my question is relative to it's in reference to the partial payment. It was noted that it counts as a missed payment. This information is, I suspect, what am I looking for? When a customer goes into this agreement or this arrangement, how is that information provided to them? People on this, I think in general, people understand that if they don't make a payment, that that works against them. But if they make a partial payment, I don't think most people believe that it works against them. So is this partial payment, if a person calls Spire and makes arrangements for a partial payment, are they informed that this still counts as against them as non-payment?
Thank you, Commissioner. The tariff for this program has not been approved by the commission or agreed upon by the parties yet. That's part of this stipulation.
Right.
And I believe we could put something in that tariff laying out some customer education and customer notification to kind of clarify some of your concerns.
I'm always interested in customer education. So
Absolutely.
thank you very much.
All right, thank you, Commissioner Coleman. Any other bench questions for the company? All right, hearing none. Thank you very much. I guess we will now hear from the staff of the commission. Ms. Myers, when you're ready.
Thank you, Judge, and may it please the Commission. As Ms. Bachstruck already mentioned, staff is a signatory to this unanimous agreement. We agree that this COVID-19 pandemic has been an extraordinary event, one that we have not seen in our lifetimes. We also filed 2 pieces of staff testimony in support of this stipulation and agreement. Both those pieces were sponsored by Kimberly Bolin and Robin Cleathermis. Ms. Bolin speaks to more the accounting aspect of this application, where Ms. Cleathermis talks more about the program development part of this stipulation and agreement. And I know that that's been an interest based on commission questions. And so I guess a few comments on just the program aspect of this stipulation and agreement, in particular the customer arrearage repayment program. So as mentioned, while it doesn't say residential customer in paragraph 16 or 17, I would agree with, I believe it was, I can't recall if it was Mr. Weitzel or Mr. Applington's comments that this was intended to be a residential customer program. And I think you can glean that from the mention of LIHEAP funding and other types of language that would only be applicable to residential customers. That said, if Spire were to propose a program for business customers, that's something parties could talk about as well. But I think for this particular tariff program, which has not been filed yet, as mentioned, and is forthcoming, it was meant to be a residential customer program. Now, I will say that Spire currently has a low-income energy assistance program tariff that was developed as part of their last rate case. And I know Ms. Cleathermis had conversations with Spire when we were talking about all of this, just to make sure how that would work. And it appears, and I think Ms. Cleathermis mentions this in her rebuttal testimony, that a customer could participate in both the low energy income assistance program that Spire currently has, as well as this tariff program that will be forthcoming. So I don't know if that answers any questions, but that is something that staff at least had looked at. And I don't know if Mr. Weitzel could possibly confirm that as well.
Yes, thank you for bringing that up, Ms. Myers. Because of the testimony provided by staff, I've given direction to our programmers that you could be in the low-income program and also part of this COVID assistance arrearage program. So yes, you could be in both of those programs.
And so I guess I would just close my remarks with saying, in addition to myself, I have with me Ms. Bolin, Ms. Cleathermis, as well as Mark Oligschlager and Natal Dietrich. And I think between the 5 of us, we'd be happy to answer any bench questions you may have.
Ms. Myers, thank you. Mr. Chairman, any questions?
Questions, Judge. Thank you.
Thank you. Commissioner Kenny?
No, Judge. Thank you very much.
All right, thank you. Commissioner Roop, any questions for staff?
No questions.
Very good. Thank you. Commissioner Coleman?
No questions. Thank you.
Thank you. Commissioner Holzman, any questions?
No questions. Thank you.
Very good. Thank you very much. We will now hear from the Office of Public Counsel. Mr. Hall, when you're ready, sir.
Good afternoon. May it please the Commission. I must admit I did not have any remarks prepared for this type of presentation other than Public Counsel sees this as a fair and reasonable reconciliation of contested matters in this proceeding. It very much follows the spirit of we are all in this together. COVID-19 is an episode of American life that we are all facing, both company and residential customers, and this provides a path forward for both interests. We have an arrearage matching program for residential customers. I'll note that Public Counsel envisioned this to be mostly as a residential, a resolution of residential arrearages and providing a fair and reasonable tracking of limited COVID-19 related costs and savings to be considered in Spire's next rate case. I'm available to answer whatever questions I can. The Office of Public Counsel has supplied our chief economist, Jeff Mark, on the line. However, he just texted me. Apparently, he may be unavailable for certain questions, but we can drag someone else in if the commission wishes to interrogate any members of Public Counsel.
Right, very good. Thank you. Any bench questions for Public Counsel? Mr. Chairman.
Questions, Judge?
Thank you. Commissioner Kenny.
No, thank you, Judge.
Very good. Thank you. Commissioner Roop.
No questions today. Thank you.
Thank you. Commissioner Coleman.
No questions. Thank you.
Thank you. Commissioner Holzman.
No questions.
Very good. Thank you. We will now move on to the interveners. First, MECG. Mr. Woodsmall, when you're ready, sir.
Thank you, Your Honor. I'll be very brief. I believe Ms. Bachstruck did a great job of going through all the various provisions. One of the provisions that I'd like to emphasize that was important to the industrials, as you'll see from Mr. Myers' testimony, was a lost revenue issue. Originally, Spire requested the ability to defer any lost revenues associated with the pandemic, as detailed in Provision 6. They have agreed not to seek those lost revenues. That was a big issue for us, one of the main reasons we joined in on this. And those were all the comments I had.
Well, thank you. Any bench questions? Mr. Chairman.
Judge.
Commissioner Kenny.
No, thank you.
Commissioner Roop.
No, thank you.
Commissioner Coleman. I'm sorry, Commissioner Coleman, any questions? I'm not getting a response. I'm assuming that's no questions. Commissioner Holzman?
No questions, Judge. Thank you.
All right, thank you. I don't think we have any questions then from MECG. MIEC, Ms. Plesha, when you're ready.
Good afternoon, Judge. May it please the Commission. The MIEC supports the stipulation. We think it's a fair balance of the interests. We also think that the parties worked hard to get to that, and we hope the Commission will approve it. I don't have any comments to add to those made by the other counsel to the parties that have spoken so far, but I just wanted to note that Greg Meyer of the firm Brubaker and Associates, BAI, is available to answer any technical questions that you might have regarding our position.
Ms. Plesha, thank you. Any bench questions, Mr. Chairman?
No questions, Judge. Thank you.
Commissioner Kenny?
No, thank you very much.
Commissioner Roop?
None today. Thank you.
Thank you. Commissioner Coleman? Commissioner Holzman, any questions?
No questions, Judge. Thank you.
All right, very good. Thank you. On behalf of the National Housing Trust, Mr. Linares, when you're ready.
Yes, thank you, Judge, and may it please the Commission. So I want to just begin by noting that since the start of this pandemic, which has seen record unemployment and mounting utility debt from customers, all sorts of utility customers, the government of the state of Missouri has done absolutely taken no steps whatsoever to help utility customers in the state of Missouri. And against that backdrop, we have an agreement now that can do something, that we can take some steps there. And NHT is a signatory to that agreement, and I'd like to briefly talk about it. The agreement reached in this case would not only allow Spire to track and recover COVID-related costs, but would also establish several new customer programs to help Spire's most vulnerable customers, to help them maintain service and avoid crippling debt during this pandemic. Those programs include a customer arrearage payment plan, which you heard the company describe. This is funded in part by company shareholders and in part from redirected energy efficiency dollars. So I think this balances expenses to shareholders and ratepayers alike. It creates a matching program that allows customer arrears to be partially forgiven. And I think it's relevant to note here that this sort of program is critical in order to ensure that the company achieves a least cost outcome and avoids the scenario in which customer debt and disconnections reach such a level where debt becomes unrecoverable, which we've seen in other jurisdictions, and resulting in the debt being borne entirely by ratepayers. So thus, I believe these customer programs are relevant to the extent that they may be necessary to limit costs during this pandemic, which is why we're dealing with them in this case. It's worth noting that other Midwestern utilities have taken significant action around bill assistance and arrearage management, payment plans, debt forgiveness, suspension of late payment fees, and disconnections. In Minnesota, Xcel Energy, a major investor-owned utility, proposed a $17 million bill credit program for its most indebted customers. In Illinois, ComEd, or Commonwealth Edison, signed an agreement with parties, I believe this summer, that includes a new COVID-19 bill payment assistance program with about $18 million in funding. DTE in Michigan pledged $13 million to help customers. So while at almost an order of magnitude smaller, this program is in keeping with what other major IOUs are doing to respond to this unprecedented pandemic. So I think that's a relevant context here. Just a last note, I'd just like to say that delay in approval of this stipulation will very likely contribute to further hardship in the form of disconnections and mounting debt on the part of customers. So NHT encourages the stipulation's swift approval. And thank you very much. Happy to take your questions.
Mr. Linares, thank you. Any bench questions, Mr. Chairman?
No questions, Judge. Thank you.
Thank you. Commissioner Kenny?
No questions, Judge. Thank you.
Thank you. Commissioner Roop?
No questions.
Thank you. Commissioner Coleman?
No questions, Judge, and I'm sorry for my delay the previous 2 times. I kept hitting the wrong button.
Quite all right. Thank you.
Thank you.
Commissioner Holzman?
No questions, Judge. Thank you.
Very good. Thank you. We will now hear from Renew Missouri. Mr. Opitz, when you're ready, sir.
Thank you, Judge. May it please the Commission. Renew Missouri was a signatory to the stipulation, and I ask that the Commission approve it. Thank you.
Thank you, Mr. Opitz. Any bench questions, Mr. Chairman? Seeing a no. Very good. Thank you. Commissioner Kenny?
No, thank you.
Commissioner Roop? Commissioner Roop, any questions?
I'm sorry.
Sir? That's quite all right.
I'm sorry. Hit the wrong button. Does Mr. Opitz want to expand on his short testimony? I'm just kidding. No questions.
Great. Thank you. Commissioner Coleman, any questions?
No questions.
Very good. Commissioner Holzman?
No questions. Thank you, Judge.
Very good. Thank you. I think we have had all the parties an opportunity to speak and had bench question opportunities for everyone. Is there anything else from either the parties or the bench before we wrap up this proceeding? Going once, going twice. All right, very good. There being no further questions, thank you very much for your participation this afternoon. We are off the record.
Thank you, Judge.
Thank you. Bye.
Thank you, Judge.
Thank you.